पर विराजमान दोनों ही टीम सदस्य रिस्पेक्टेड बालेंद्र यूनिवर्सिटी जी, रिस्पेक्टेड दोनों लोगों को सम्मानित करने के लिए अंगवस्त्र पुष्पवृक्ष से सम्मानित करने के लिए हम माननीय निदेशक महोदय से आग्रह करते हैं। दोनों ही सदस्य को अंगवस्त्र पुष्पवृक्ष से सम्मानित करने की कृपा करेंगे। माननीय निदेशक महोदय, respected teachers and noteworthy participants की उपस्थिति में माननीय न्यायालय की अनुमति से अग्रतर कार्यवाही प्रारंभ की जाती है।
The council seeks permission to hold the bench collectively as Judicial. Much obliged. The council is here in the matter of the state of Abhiram versus David, respondent. On the behalf of the account, that is state of Delaware. The council seeks permission to state the jurisdiction of the petition. The petitioner invokes the jurisdiction of the Honorable Supreme Court of Korea under the Article 124, Clause 1, Sub-Clause 3 of the Constitution of Korea. Article 31, Clause 1, Sub-Clause 3 grants Supreme Court the jurisdiction over the criminal appeals from the High Court in some cases. The council seeks permission to read the facts of the bench. The Republic of Korea is a quasi-federal country with 35 states and a strong central government. Its laws are similar to India. Belarus is one of the most developed states of Korea, and the David, that is 29 years old, and the Emma, 24 years old, was resident of Marigold, Venezuela. They are married and had a daughter, Sophie, on 4th September 2010. Initially, their marital life was smooth, but after their birth, Emma noticed changes in David's behavior. He became rude, aggressive, and violent over travel matters. Concerned about the behavior, Emma took David to the Dr. Matthew, defense witness one, psychiatrist who diagnosed him with a bipolar disorder and prescribed medication. However, despite the treatment, David's violent behavior continued and he physically assaulted Emma. On 5th December 2010, around 11 a.m., neighbors heard cries and shouting from David's house. Their neighbor found Emma unconscious and injured and covered in blood. He saw David attempting to hide 7-inch axe in the garden. On his complaint, police arrested David and Emma was taken to the hospital where she was treated by Dr. Andrew on same day. On 6 December 2010, Emma regained consciousness and gave a time declaration to the Inspector Joseph. She stated on 5 December at 9 a.m., David attacked her with an axe during a fight in the cabin. The Emma succumbed to her injuries on 8 December 2010, primarily due to the fatal wounds in her lower abdomen. Their daughter, Sophie, was sent to the government child center. David claimed that the time of the attack, he was unconscious due to medical condition and had no memory of attacking Emma. The final report on the 3rd February 2011, and the David was charged with the Emma murder under Section 102 of the IPC. So the council seeks permission to go with the issues also placed. The issue number 1, whether the time declaration made by the deceased Emma is admissible and reliable evidence in determining the guilt of the accused David. That the time declaration which is made by the Emma who is deceased is admissible and reliable in determining the guilt of the accused because the statement which is made by the Emma is corroborated and conclusive by the evidences, and the statement which is lodged by the Emma is in front of Inspector Joseph, and corroborated with the forensic reports, the recovery of the acts and reading David fingerprints directly connect to the accused to the weapon used in the fatal attacks. And the doctor who treated Emma testified that the cause of death was due to the axe attack and the injury to the abdomen proved fatal. He further stated that Emma was mentally fit at the time he was just making a statement as a dying declaration. And the injury which is caused to him is very fatal. He further stated that Emma was mentally fit and she was dying declaration also from the Inspector Joseph, and also the doctor at the time he was stating the dying declaration, the doctor was also satisfied that she was mentally fit and conscious. And later on there was an eyewitness also, Mark, which is testified that whenever she was, the Mark was neighbor of that Emma and David, that Mark would just hear the sounds coming from the David's house, loud cries and something else. He would just investigate their house and then reach, and then they will see Emma was laying down on the floor with a full of blood, and after that the Mark would just see that David was hiding the axe in the garden. And after that he would just call the police officer, and after the police officer then reach, and immediately the Emma which is admitted to the hospital, and the child which is go to the child care department. Whether there are the two questions which is arising from this issue, that is admissible and reliable. There are 4 points which is I am to conclude and just point it out. First of all, the dying declaration which is made by the Emma, which is before inspector, that is admissible, which is allowed in several cases. That is same versus State of Punjab, in this case where the Supreme Court held that any kind of dying declaration which is made before the inspector, police inspector, it will be corroborated and admissible. And the second one is eyewitness. There is a conclusive proof of eyewitness in which the Mark, who is the primary witness of this incident, he just saw the crime scene at that time when it is happening, and then he was just saw the incident and just see the David to hiding the axe and condemn the crime scene. And there is a maxim also, Nemo Moritus principle, which means that man will not meet with the life in mind, which means that whenever the person is dying at the last stage, he will never lie.
Mr. Counsel, you like to suggest that what was the paper part? Avajan?
Yes, Your Worship.
Yes. Would you like to assist this court that on which information the FIR was lodged, whether it was the statement of Mark or it was the dying declaration of Emma? And dying declaration comes into play afterwards because it has been stated in the Muzaffarpur problem that it was Inspector Joseph who took the statement. Nowhere it is written. That's the cave dying declaration. So whether, my question is, which information was the genesis of lodging of FIR? Whether it was the declaration or it was the information given by Mark, who was the neighbor who just reached after the alleged occurrence and found David who was trying to hide the alleged weapon in the garden. So which information set the criminal law into motion? Which information?
So actually the information...
And with the two information, as it is stated here, Based on Mark's statements and Emma's declaration, and FIR was registered. Whether two informations are necessary for registering the FIR, or was it only a statement of Mark, the neighbor, or the dying declaration of Emma?
That the FIR was lodged on the information of the mark, which is eyewitness of the incident. And the main principles of the criminal law is that whenever there is an incident caused in any happening, which means that, let's suppose there was a crime which is committing in this college, in this out of anywhere, and someone who is the witness of that crime, so he can lodge an FIR at the inquest.
And I'm just getting to know from you that in this case,
Yes.
which information was responsible for lodging of FIR? Whether it was Mark's statement or Emma's dying declaration? Please. And limit yourself only to the facts of these cases.
Where do you mark statements? May I proceed with second issue? Whether the medical evidence regarding the disease, injuries, and the cause of death establish a clear link between the attack and the fatal injuries. That the injury which is caused to the deceased, which is a directly connected to the incident, which means that the injury which is caused by the acts which is committed by the devil, and the cause of death, which is an acts which is a very common fatal injury which is caused to her. With due permission, I have some kind of research paper. May I present?
Stick with the time. You're beyond 10. I will stick with the time.
Those research people which is testified whenever there is a autopsy report and there is a medical evidence which is strongly corroborated in the case of law also. And there is also other two report which is stating about the whenever there is a person with diagnosed with a bipolar disease, which means that he is being capable. When there is a person who is diagnosed with a bipolar disease, which means that he is being capable to be murder, but not in the case of first stage. At the David which is recognized the bipolar disease is maniac period, which is first stage of period. And those report which is stating about that whenever the person who gets the bipolar disease, which means that the person who gets to the third at the last stage of disease, then he capable to murder. And for those circumstances, he being not able to murder. And the fact which is requiring that the medical evidence and the injury which is caused to the disease, which is clearly establishing a murder, which is the intention by the devil. And there's another forensic evidence is that there's a fingerprint which is on the X. And there's a correlation with the identification statements also. And there are so many categories of the cases in which the Supreme Court held that.
My question to you is whether this court is bound by the opinion given by Dr. Andrew, because he is the doctor who has not only treated Emma, but also testified the cause of death. So, meaning is clear that Andrew is the person who not only treated Emma after the alleged offense, But he also testified that cause of death was due to the X attack. So he was also doing the autopsy and he was also present at the time of a statement taken by Inspector Joseph. He is the doctor who is doing 3 jobs. So, and my question is whether this court is bound by the opinion of that Dr. Entry. If yes, how?
Actually, the recommendation by the Dr. Andrew, which is a conclusive because that doctor, which is an experienced doctor, and the statement which is delivered by him, because the injury which is caused to Emma, which is untreatable, because the organs which is heavily damaged by the axe, and it will be not recoverable. That's why the statement of the Andrew said that it was untreatable, because the damage of the internal damage of the disease which is not be treatable. And the statement which is delivered by the Dr. Andrew is that the cause of death, which is a sharp-edged weapon, that is axe. Because whenever the crime which is whenever the crime is committed by the David on 5 December, and that the intention, that the intensity of the hitting of an axe, which is very brutally, and that cause that she will not survive.
What are the requirements to qualify any statement in damage declaration? And what do you mean by expert?
Yes, sir. There is an expert opinion which is.
No, I'm not asking about opinion. I'm asking about to qualify any statement in damage declaration. What are the ingredients?
What are the ingredients of the?
Secondly, who is expert?
Pardon, sir.
Who is expert? Expert.
Who is expert? I am going with the first question with you. That the initial ingredients of the time declaration, which is held on the question of case, in which the Supreme Court held that there are the 4 principles which have to be followed by the all means of time declaration. First, the time declaration must be before magistrate. Second, the time declaration before a doctor in charge whenever the hospital will be at the time, that is CHO, CMO, and the doctor must be clarified when she was taking the statement of time declaration, she must be in full consciousness. And third one is the time declaration must be in the question answer form. And the fourth one is the time declaration must be a probability form also.
एक छोटा सा सवाल का आप जवाब दें। इस केस में जिस टाइम डिक्लेरेशन को आप चुनौती दे रहे हैं, that was not recorded before magistrate, which you said that it ought to be. Secondly, doctor in charge was not present because he has given the statement before the inspector. Third, there is no certification that time declaration was duly certified the doctor. So these 3 are not here, as you said. So how can you say that she was in a position to make proper time declaration? What you stated, that is not in consonance with the case of your case, because you are the agreed by the judgment of the High Court and you have approved this court. Yes.
Your Worship, the main point is that the time declaration which is made by the Emma, that is admissible because the time she was made her statement, because no one to know when she was done. At that time, he was just stating her statement, the time declaration. So the police officer doesn't have enough time to call the magistrate. There are so many cases where the Supreme Court, Honorable Supreme Court, allowed that whenever the time declaration made before any police officer, constable is admissible, because the circumstances is different from different cases. That's why.
मिस्टर काउंसिल, आप ये कोर्ट के सामने बताएं कि घटना के समय एक्यूज्ड फिट स्टेट ऑफ माइंड में था, उसको घटना की जानकारी थी, तो ये नॉलेज ऑफ डिफरेंस कि वो घटना कर रहा है, ये कोर्ट को कैसे?
Actually, sir, the problem is that the David, he knows he is in mental of this state, but he's just taking the plea of insanity to exempt his criminal liability. Because when he was at the time, he was committing the crime, he was fully consciousness because whenever the person
That was concerned. And while you are in a fit state of mind,
and proving my
while knowing the outcome of that offense, how can you say?
and proving my may I? So the incident which is caused, let's suppose the David which is unconsciousness, okay, and he was just unintentionally, he was not legally insane, he was doesn't about what he's doing right now, but is wrong, but is right. Okay, he was just committed murder, and afterwards he just consciousness automatically, and just see the wife who's just laying down with full of blood and he holding an axe and was deciding that and not calling the police officer and ambulance, he was just hiding her. If the person who is unconsciousness, he was just, there was a partner, the life force which is lying down on the floor, and he was just saying that I will be murdered. The police will be convicting me. How is it possible? It was intentionally murder, sir.
It is not written anywhere in these. Last question, sir. Tell me one thing. Do you know which provisions suggest expert opinion in Indian Evidence Act?
Yes. Yes, Manish. The section of 45, which is expert opinion, which states that the court is not obliged to follow the expert opinion, but the expert opinion which is widely to be necessary, the discretion of the court which will follow the expert opinion or not.
Okay, thank you.
May I hold the second speaker?
Yes. What's your name?
Swarnit Soram.
May I proceed with the fourth issue, Your Worship? The fourth issue is that whether prosecution has proven the case of murder under Section 302 of IPC beyond a reasonable doubt in the light of accused medical condition and the surrounding circumstances. The appellate with profound respect for its honorable court contends that prosecution has brilliantly proven the case of murder under Section 302 of IPC, casting aside any shreds of doubt, even in the light of accused's medical condition. The core intent of this case is intent, and the prosecution has meticulously established David's intent of the action that he did on that very deliberate and faithful way. Emma's dying declaration, recorded by Inspector Joseph, PW1, stands as a powerful and unshaken testimony against the accused, guarded by maxim, nemo correctus, price meter mentor, a dying person is presumed to be truthful. As upheld in the case of Lakshmi vs. State of Maharashtra 2002, her statement needs no corroboration. Yet the prosecution fortifies its case with forensic evidence linking to David weapon, that was his mark on the axe, fingerprints, and the mark statement, his eyewitness testimony account seals it with a clarity for the conviction. Dr. Andrew PW2 medical testimony and the post-mortem report lay bare and fatal consequences of David's act, leaving no scope for ambiguity. The principle of causa post nocas, the immediate cause, rings loud and clear here. David's axe attack was direct cause of Emma's death, and Honorable Supreme Court in the case of Bhagwan Das State of NCT 2011 rightly emphasized that the vital role of medical evidence in strengthening a prosecution's case, and here, medical findings stays with harmony with circumstantial evidence, creating a narrative that cannot be doubted. David's attempt to invoke Section 84 of IPC, claiming insanity is followed with its core here. The burden of proof under Section 105 of the Evidence Act lies as verified in Dayabhai Chagnani versus Thakkar versus State of Gujarat 1964, squarely lies on defense. The Honorable Court in Surendra Krishna versus State of Jharkhand 2011 further held that mere medical evidence of a disorder is not sufficient unless it conclusively proves accused inability to distinguish what is right and what is wrong, and Reeves' conduct, post-conduct, after the act, hiding eggs is clarifying conduct indication of his awareness and intent, dismantling his plea for insanity. Harimandan Babubhai Patel versus State of Gujarat 2013, the Supreme Court held that one forensic evidence, eyewitness testimony, and motive established a direct connection between the accused and the murderer. The prosecution orders fulfillments. Any minor inconsistency did not
Ms.
affect
Counsel.
conviction. Yes, Your Lordship.
What are the legal face of admissibility and reliability of the crime declaration in the absence of corroborative evidence?
Do I have to state the cases, Your Lordship? In the case of Sambar Babu Khel versus State of Maharashtra, it was informed that a lying declaration can be the sole base for conviction if it is free from suspicion and corroborated by circumstantial evidence. And also in Lakshman versus State of Maharashtra, 2002, it was clarified that a lying declaration does not require corroboration if it is consistent and inspires confidence, and Emma's statement does that.
How can you say that a statement recorded by inspector in course of his investigation
is a direct declaration? Because it is neither made in the presence of doctor nor in the presence of magistrate. There is no certificate to decipher that the patient or the declarant was in a proper state of mind to make that declaration. And secondly, the defense is of unsoundness of mind. So tell something. How you lost your case in Honorable High Court. That is why you are appealant here.
Yes, Your Lordship.
So there is a presumption of judgment in favor of respondent. How will you rebut these two things? First, the presumption of judgment, and secondly, whether the declarant Emma, deceased, was in such a state of mind that a statement recorded by inspector to be taken as right declaration.
May I continue, Your Lordship? Your Lordship, in the fact, it was stated that Emma was mentally fit when she was giving her dying declaration, and this was said by Dr. Andrew, PW2. Shall I continue with this point only?
secondly, what about the presumption of judgment, which is in favor of respondent?
Which one judgment, Your Lordship, in favor of respondent? Pardon, Your Lordship. Shall I continue with the next issue? The fifth issue is whether the acquittal by High Court on the basis of legal insanity is legally sound and in accordance with the established standard of mental fitness required for the defense under Section 84 of IPC. The appellant, with deep reverence for the wisdom of this honorable court, submits that acquittal by David by High Court under Section 84 of IPC is legally sound and fails to meet the stringent standards established by defense for legal insanity. Section 84 of IPC provides a narrow escape for those who, due to unsoundness of mind, were incapable of understanding the nature of their action and distinguishing between what is right and what is wrong. This is not a presumption, but an extraordinary defense that demands substantial proof. The principle of onus probandi, the burden of proof, lies on the one who asserts, is crystal clear in Dayabhai Chaklani Thakur versus State of Gujarat, 1964. The defense must convincingly demonstrate not just mental illness, but legal insanity. Yet, defense has presented a mere diagnosis of bipolar mood disorder without proving David's incapacity to comprehend the nature of act when he seriously attacked. The High Court's reasoning is fundamentally flawed, as it disregards the principle articulated in the case of Surendra Krishna v. State of Jharkhand 2011, where the Supreme Court established that mere medical evidence of mental illness does not suffice unless established a total cognitive breakdown at the time of that incident. David's behavior believes his claim of insanity, his attempt to conceal the weapon post-crime, as testified by Mark, the eyewitness, reflects awareness of wrongdoing and a clear intent to evade his responsibilities. This is antithesis of the disorientation and lack of judgment required for varied defense under Section 84. The maxim, actus non fixit rea nisi mensit rea, an act does not make one guilty unless the mind is guilty, is purported in criminal law, but cannot shield an accused who actually demonstrated clear intent and awareness. High Court relies solely on Math's testimony, ignoring the precedent set. Rebuttals was his state of Madhya Pradesh, 1971, which mandates accused conduct before, during, and after crime must be medically examined when evaluating a plea of insanity. And in a recent case, Shiva was the state of Kerala 2023. It reiterates that defense of insanity is an exceptional plea and must be proven with precision, clarity, leaving no room for ambiguity. Hence, the appellant respectfully submit that acquittal by High Court is legally and unethically contrary to established jurisprudence. May I move the prayer portion?
Just a moment. Could you tell me that why McNaughton rule, the defense of McNaughton rules, which has been mandated in Section 84 of the IPC, cannot be taken in assistance of this case? And what is the difference between legal insanity?
The Council seeks permission to collectively refer the bench as your lordships. Would you like me to state the facts again, or should I start with the issues?
Go ahead with issues.
The first issue here, the lordship, is whether the right declaration made by the deceased Emma is admissible and reliable as evidence in determining the guilt of the accused David. That it is humbly and most respectfully submitted to this Honorable Court that in given state of affairs, the dying declaration by the deceased Emma is neither admissible nor reliable as evidence in determining the guilt of the accused. The first thing I would like to say is the admissibility of a dying declaration is primarily governed by Section 32, Clause 1 of the Indian Evidence Act, which says that which permits a statement made by a person who is dead or who cannot be found or who has become incapable of giving evidence or whose attendance cannot be procured without an amount of delay or expense which under the circumstances of the case appear to the courts unreasonable. When the statement relates to the cause of his death or to any of the circumstances of the transaction which resulted in his death in cases in which the cause of person's death comes into question. Your Lordship, the first thing is the statement recorded by Inspector Joseph, which later became a dying declaration. Inspector Joseph, when I reiterate his words, what he stated in his statement, Inspector Joseph, investigating officer of the case, testified that Emma's dying declaration blamed David for the attack. He also stated that the axe used in attack was recovered from David's garden and had David's fingerprint according to forensic report. Breaking down PW's one statement. When I take the statements, the first of all, if Emma gained back her consciousness on 6th December itself and died on 8th December, why the statement was not recorded before a magistrate, even though the prosecution had enough time to do the same? As in Panipat versus State of Gujarat, Honorable Supreme Court held that a dying declaration recorded by a magistrate carries greater evidentiary value than one recorded by a police officer or a private person. This is because magistrate is presumed to be impartial and unbiased and is expected to follow proper procedure for recording the declaration. And I am not denying the possibility that it will not be recorded by a police officer. But if they had enough time to get the statement recorded by a magistrate, then why didn't they do so? The second thing is, why this statement was not recorded in question and answer form? In Ramesh versus State of Tamil Nadu, the Supreme Court held that a dying declaration recorded in question and answer form is admissible. while the statement was not videographed, for making their evidence reliable, they could have recorded the declaration, but they did not, even though they had enough time. Reiterating the words of Justice R.S. Sodhi while deciding Jessica Lal murder case, I agree that one can do the videography of dying declaration. It can be in recording also, but videography is more accurate because the person writing may miss out a few words, or there may be some miss out of words, or there may be some misinterpretation in that process. Videography is much safer, as most of the cases are now being decided on basis of CCTV footage itself. Under 161 of CRPC, a provision has been made for police to videograph the statement of witnesses. Coming to the next point, it is said that recovery of weapon was done from David's house and his garden. Here, the discovery of weapon under question is not recovered by the statement of the accused under section 27. It is recovered from the statement of Ma. The second thing is reliability on forensic report could not be placed as David was the owner of his house and his fingerprint can be found on any of the objects. The third thing is the X, which is the alleged weapon used for the attack. The forensic team did not submit about any blood stains and whose blood it was. Now coming to inadmissibility of the dying declaration. In Ukaram versus State of Rajasthan, the Supreme Court cautioned against relying solely on uncorroborated dying declaration, as there is a discrepancy in the forensic evidences, as it does not tell about the blood stains found on the X. And in Ukaram versus State of Rajasthan, the Supreme Court cautioned against relying solely on uncorroborated dying declaration, especially when there are doubts about its veracity. Corroboration can come from various sources such as eyewitnesses' testimony, forensic evidence, or circumstantial evidence.
Please hold on.
Okay, Arun.
The dying declaration was duly supported by Dr. Andrew, who stated before his deposition that he was mentally fit when he made the dying declaration. Secondly,
Yes, Lordship.
you said that the house was occupied by David.
Yes, sir.
So it is duty of the David, the burden of proof sits on David to rebut the allegations, because what happened was in his own house and especially within his own knowledge. So he is duty bound also, and the burden of proof sits on him to explain the circumstances.
I would like to put, firstly, on this point, that benefit of doubt must be given to the accused, my lordship. The thing by which we cannot rely on the dying declaration is absence of cross-examination. One of the inherent weakness of a dying declaration is the absence of cross-examination. The accused is denied the opportunity to challenge the declarant's testimony, test their credibility, or expose any inconsistency or biases. This lack of cross-examination necessitates a higher degree of caution and scrutiny on the part of the court. Yes, Lord, sir.
ऑडियो वीडियो रिकॉर्डिंग नहीं हुआ स्टेटमेंट का 161।
Yes, sir.
ये प्रोविजन कब आया था? ऑडियो वीडियो पर रिकॉर्डिंग से स्टेटमेंट लेने का 161 का स्टेटमेंट।
I am not relying on that, sir, but the thing is,
प्रोविजन कब आया और किस होता है?
Sir.
You will read it.
Yes, sir. What, sir?
161 का वो रिकॉर्डिंग नहीं किया गया, ऑडियो रिकॉर्डिंग, वीडियो रिकॉर्डिंग, वो प्रोविजन कब आया है कानून में? और ये एविडेंस करता है।
Sir, I am not relying on that thing only,
Okay.
but I am creating a reasonable doubt.
What is your defense in this case?
My defense is legally
क्या
sorry.
डिफेंस दिया, लीगल इंसेंटिव दिया है?
Yes, sir.
मतलब आपने हत्या की है, आपने वो एक्ट किया है।
No, sir, there is no such statement by the accused that he did that.
लीगल इंसेंटिव का आपने ये डिफेंस लिया है ना?
He was unconscious at the time and he did not even know what he did. Yes, sir.
आपने लीगल इंसेंटिव का लिया है।
Yes, sir.
मतलब वो जो घटना घटी है, वो आपके द्वारा हुआ है, लेकिन वो इंसेंटिव में होता है। ठीक है?
Yes, sir.
What is difference between legal insanity and medical insanity?
A person can be declared medically insane, but for being legally insane, he must be not competent at the time of doing the act, that he was unconscious of the act, that he did not know the nature of the act, whether it is right or wrong.
बस इतना ही या और भी कुछ है दोनों में डिफरेंस
There are multiple differences in that.
अगर आप जानते हो तो नहीं तो कोई बात नहीं
No, sir. I would like to proceed further with the next one.
तीसरे इशू पर आप जाएं
Third issue. Whether the medical evidence regarding the diseased injuries and the cause of death establishes a clear link between the attack by accused and fatal injuries. Talking about the medical evidence regarding the link between the attack by accused and fatal injuries, PW2, Dr. Andrew, who treated Emma, that the cause of his death was injury below her lower abdomen. He states about this one injury that proved to be fatal. Dr. Andrew's statement was stated as opinion of expert under Section 45 of Indian Evidence Act. But the evidence given by medical expert is only an advisory character and does not form conclusive evidence.
मिस्टर कौंसिल, ये बात प्रूव है वो घटना घटी है आपके द्वारा बस डिफरेंस इतना ही है आपका कि आपने लीगल इंसेंटिव का क्रिया किया
Yes, Your Lordship.
उस घटना में नजर
So I have to prove my point of legal insanity. Okay. Okay, Your Lordship.
वो प्रूव है वो घटना घटी है वो डेथ हुई है वो आपके कारण हुई है अब आप सेम जो उसमें है
तो सामने
सैंपल्स ऑफ फाइल not knowing the nature of the offense, you have बस इतना भी
Okay. I would like to come to issue number 4, as Your Lordship suggested, that it is humbly and respectfully submit that the prosecution has failed in proving Emma's murder case under Section 302 of IPC beyond a reasonable doubt in light of the accused's medical condition and surrounding circumstances. In the realm of criminal jurisprudence, the burden of proof rests squarely upon the prosecution to establish guilt, but beyond a reasonable doubt. This fundamental principle, a cornerstone of fairness and justice, is particularly crucial in cases involving grave offences such as murder under Section 302 of the IPC. When the prosecution fails to discharge this burden, particularly in the face of compelling mitigating factors like the accused's medical condition and ambiguous surrounding circumstances, a conviction becomes untenable.
आपने ये कहा
Yes, Your Lordship.
कि ये घटना मेरे ही द्वारा हुई, लेकिन मुझे जानकारी नहीं कि कैसे हुआ, कब हुआ, मैं उस मानसिक स्थिति में नहीं था। तो फिर उनको रिजनेबल डाउट से क्या प्रूफ करना है? प्रूफ तो आपने करना है कि जिस समय ये आपके द्वारा घटना घटाई है, आप उस स्वस्थ चित्त में थे ही नहीं। यू आर सफरिंग ऑफ लीगल इंसैनिटी। और दूसरा, आपने थर्ड इशू में कुछ भी नहीं बोला, whether the evidence presented by defense witnesses sufficiently establishes that accused was in unconscious state due to his medical condition at the time of attack. इस पर आप कुछ कहना चाहेंगे?
Yes, sir.
फर्स्ट स्टेज ऑफ बाइपोलर मोड डिसऑर्डर,
Yes, Your Lordship.
ये कैसे आपको डिफेंस दे सकता है अपनी वाइफ के मर्डर से जो आपके हाउस में हुआ है?
आप करें या दूसरे भी आपके स्पीकर कर सकते
No, Your Lordship, I will conclude this statement and then we further proceed. In this case, the onus of proving possession beyond a reasonable doubt is on prosecution, and prosecution clearly failed to establish the links. Not a medical expert relying on a report by National Library of Medicine by US government. It says that stab wounds to the abdomen usually have a much better prognosis than gunshot wounds. And coming on the point of Section 84 of IPC, I would like to say that he was unconscious at the time of doing act because he did not run away from the site of the murder. He was there. As the eyewitness Mark stated that he directly went into the house as the door was ajar. And this proves that it proves that he did not do it intentionally. If he had intention, he could have hit her at the soft spots, not abdomen.
Have you read the David McNaughton's case judgment? Have you gone through that judgment, McNaughton?
Yes, sir.
Who was McNaughton? आपने उस judgment को आपने पूरा detail
No, sir, just the judgment, the proper judgment I read.
और आपने जीवन का केस पढ़ा है, रतन लाल का केस पढ़ा है। क्या रतन लाल का रेशियो इस केस में एप्लीकेबल होगा? रतन लाल में ये कहता है कि आपको सराउंडिंग्स भी देखना है, तो आपके हाथ से, आपके नेबर से वो वेपन को छुपाते हुए देखा है।
केवल छुपाते हुए देखा है, उसने एक्ट तारीफ करते हुए नहीं देखा।
सेक्शन 8 आपके अगेंस्ट में जाता है। इंडियन एविडेंस एक्ट।
Your Lordship.
Motive, preparation, concealment, conduct, etc.
Yes, Your Lordship. मार्क ने जो कहा है Your Lordship कि उसने देखा, लेकिन उसने यह नहीं देखा कि उसने एक्ट जिस समय कार्य किया उस समय वो किस स्थिति में था। उसने बस बात की बातें बताई और केवल सोली इस बेसिस पे कि उसका आफ्टर कंडक्ट किया था, उस बेसिस पे कन्विक्शन नहीं किया जा सकता है। वो उस समय इस स्टेट ऑफ शॉक में था कि उसको पता ही नहीं था कि उसका नेचर ऑफ एक्ट क्या है, इसलिए तो वो वहां पे था। Your Lordship वो भागा नहीं, वो वहीं पर खड़ा था और वो समझ रहा था कि अब क्या हो गया, ये मेरे हाथों से ये मैंने क्या कर दिया।
आपने अपने पूरे बहस के दौरान डॉक्टर मैथ्यू जो आपका लगातार इलाज कर रहे हैं उनके बारे में आपने कुछ भी नहीं कहा है, तो आप कैसे इंसैनिटी का डिफेंस ले रहे हैं? आप अपने डॉक्टर का ही रिपोर्ट नहीं बोले।
It is already mentioned in the memorial and I am not stated it because I was dealing with other issues. I would like to deal with it. That Dr. Matthew has proven that he was medically insane because legal insanity is on discharge of this honorable court. They have to decide whether he was legally insane or not. But on basis of his statement, the doctor's statement, he was insane at that particular point of time when he was doing the act, as he was suffering from bipolar mood disorder, and maybe this could have been possible that he had not gone to the doctor in a long time, and his stage was. His stage further aggravated in this whole circumstance. Maybe he has shifted to the second bipolar disorder stage. There's no such proof that whether he was in first stage or second stage.
Court does not go by what could happen or
but
what are the chances of such happening.
But Your Lordship, when there is a reasonable doubt, then the benefit of doubt must be given to the accused.
It is not a question of reasonable doubt. You are taking the defense under general exceptions of IPC. You have to prove your case, otherwise you will be convicted for life.
Yes, sir.
You have to prove your case because you have taken the defense. You I killed, but that was I was empty-headed. I was legally insane. I was suffering of some schizophrenia, bipolar disorder, etc. Or even unsoundness of mind. Then you have to prove your case.
Yes, Your Lordship.
Take us.
Let's keep up.
The council seeks permission to conclude the matter further from where my co-counsel has concluded. May I proceed? First of all, I would like to state section 84 with the due permission of this court. What does section 84 of IPC states? It starts with the word nothing. Nothing is a saving clause. Nothing is an offense which is done by a person who is committing the offense. It is stated that nothing is an offense which is done by a person who at the time of doing it, where it clearly states that at the time of doing the act, neither before the commission of act or after the commission of act. It clearly indicates that at the time of doing that, whether the person was insane or not, by reason of unsoundness of mind. By reason of unsoundness of mind clearly indicates the pre-existing medical condition of accused, which is clearly testified by the defense witness Dr. Andrew. who have stated that the accused was going through the first stage of bipolar mood disorder.
It is Dr. Matthew, not me.
Sorry, sir. It is Dr. Matthew who has clearly stated that the accused was going through the first stage of bipolar mood disorder. But it could have been that the medicine might not have been affecting the correct thing, and it would have been improved to maybe it would have been suffering from the final stage. After that, it is clearly said by reason of unsoundness of mind is incapable of knowing the nature of the act, or that he is doing what is either wrong or contrary to law, that is against the law. As the defense provided by section 84 of the IPC, it clearly states that nothing will be an offense which is done by the accused who at the time of doing it, neither before the omission of act or after the commission of act, is incapable of knowing the nature of the act due to the unsoundness of mind. That is what the plea we are taking in behalf of the accused David. Now, coming to the issue from where few more issues which my co-counsel has not stated, and the appellant has stated that they are stating that there is a strong connection between the weapon and the accused. We are stating that there is no connection with the weapon and the accused, and there should be blood stain on the axe, which is missing. And first of all, there is a contradiction in the time declaration of the deceased, and in the while producing the witness of prosecution, witness 3 Mark stated that at about 11 a.m. loud cries and shouting were heard coming from David house. While Emma making a dying declaration has stated that at about 10 a.m. there is a gap of 1 hour. Now, how can a single injury be the cause of death? It can be fatal but not a cause of death.
Just a moment. You have taken your defense before the sessions court of legal insanity, sir. You have also taken defense in the High Court, where you have been acquitted, and you are here also taking the defense of section 84 IPC, sir. So whether the blood stains were present on that axe or whether she died of that injury, it is irrelevant. The question only limited to whether the ingredients of section 84 are fulfilled or not. What do you say about McNaughton rule? And secondly, in a case of Ratan La, very important case regarding the insanity, it has been stated, it is of state of LP 2002, whether the accused was such a state of mind as to entitle to benefit from section 84 of IPC can only be determined from the circumstances that preceded, that attended and followed the crime. After the crime,
You were seen by your neighbor that you were trying to hide the murder weapon. What do you say? What is your explanation?
So, explanation is that of the IPC, which clearly states that at the time of doing it, I am just putting on the word it, at the time of doing the act, the accused was in unconscious mind. After, if he is gaining the consciousness or not, it is not the matter of section 84. 84 is just limited to the condition of accused at the time of doing the act, not before or not after.
but Supreme Court has different version. पहले क्या हुआ, उस समय क्या हुआ और बाद में क्या हुआ, इन तीनों को मिलाकर रतन लाल के केस में ऑनरेबल सुप्रीम कोर्ट ने ये कहा है कि सिर्फ उस गोली मारने के बाद भी देखना होगा कि आप एक सेकंड में आपका बाइपोलर डिसऑर्डर नहीं था, आपने मारा तो उसके बाद क्या आपको लगता है कि आप हथियार छुपा रहे थे तो मारने के चलिए दोषी नहीं, तो क्या आप 201 पे दोषी नहीं होंगे?
Sir, I was not hiding the acts. It would be possible. No, sir, it might be possible that I was keeping it on the place correctly, sir.
That is the garden. Someone puts beneath the
Sir,
garden.
it was already in the garden from where I took it.
Okay.
As And as sir stated that there is a contradiction in time of 1 hour, then whether the accused was hiding the acts till 1 hour, there is no credibility of evidence. And now coming to the next issue, that whether the prosecution has proven the case of murder under section 302 of IPC beyond reasonable doubt in light of the accused's medical condition and the surrounding circumstances. The accused's medical condition, if demonstrably impacting their cognitive function or volitional control, can significantly underdetermine the prosecution assertion of mens rea, and guilty intent of guilty mind was not here. For instance, the accused was suffering from a severe mental illness, neurological disorder, or was under the influence of potent medication at the time of alleged occurrence, the ability to comprehend the nature and consequences of their action may have been compromised. While stating the judgment of Surendra Mishra versus the state of Jharkhand, the Supreme Court emphasized the importance of considering the accused's mental state while determining criminal liability. Again, sir, as stated by Honorable Court, in Ratal Lal versus state of Madhya Pradesh, the court recognized that even temporary mental incapacitation can negate the requisite mens rea for murder. Beyond the accused's medical condition, the surrounding circumstances must be meticulously analyzed to determine whether they unequivocally point towards guilt.
Just hold on. These are the surrounding circumstances which shows when you are hiding in an accident, which is the murder weapon, that no one could see you, and when you are arrested, you are taking this defense. What I did, I was not in such a mental condition. There was no culpable mind on my part. There was no mens rea. It is a case of a captus non facitory, nisi mens rea.
Sir,
both the things are contradictory to each other. Surroundings, what you refer to the judgment, it says.
sir, it's not only the hiding of acts, the surrounding circumstances. If I have been intentionally murdered my wife, then I should have done it in a closed room. Why would I opened the gate that someone could come and see what I am doing? Why did not I run away from the place?
इस प्रश्न के उत्तर में मैं ये भी को कह सकता हूँ कि यदि आप अपना मर्डर बंद रूम में करते थे, आप वहाँ से भाग भी सकते थे, तो मैं ये क्यों ना कहूँ कि आपने एक डॉक्टर से बहुत दिनों तक अपना झूठा इलाज करवाया। उस सारा ड्रामा आपका इसके लिए ही था क्योंकि एमा को एक बेटी हो गई थी और बेटी होने के तुरंत बाद ही आपका उससे संबंध खराब होने लगा। वो खुद डॉक्टर के यहाँ गई, आपका लगातार इलाज चला और व्हाट द केस सेज, इलाज के दौरान भी वो बढ़ते गया।
Sir, I have a defense on that. मैं डॉक्टर के पास नहीं गया. It is my wife who took me to the doctor. And whether my daughter was the reason for this or not, I should have killed my daughter too. लेकिन बच्ची पर कोई अटैक नहीं हुआ.
पूरा होता भी नहीं है. जो केस है बस उसी पर कि मैं उनको रूम में बंद कर सकता था या मार सकता था. जो हुआ है सिर्फ उनके पर एक होता है.
Sir, just I am taking the plea of section 84 that at the time of doing the act, I was in an unconscious state of my mind, and I have not remembered anything that how it occurred and what the things happens. Now, further establishing the only one fact of section 84, I would like to conclude the matter with my prayer, if the court permits. May it please this honorable court, the respondent, namely David, most respectfully prays this honorable court of Oria may be pleased to uphold the judgment of acquittal passed by the honorable court of Valera in criminal appeal number 875 of 2014, dated 5th September 2016, and thereby affirms that the respondent is entitled to the benefit of section 84 IPC on account of legal insanity. Hold that the defense of insanity is well established in view of the following. The medical evidence as testified by Dr. Matthew, defense witness 1, confirms that the respondent was suffering from bipolar mood disorder, which can cause violent and involuntary conduct. Second, the respondent's history of psychiatric treatment and testimony of his brother, defense witness 2, further substantiate his mental incapacity. The legal standard under section 84 IPC requires proof for an inability to understand the nature of the act, and the evidence on record sufficiently establishes the same. Disregard the dying declaration of the deceased, Emma, on the grounds that the respondent lacks of mens rea due to his medical condition, vitiates the culpability required for an offence under 302 IPC. The circumstances in which the statement was made do not conclusively rule out the possibility of misapprehension or exaggeration, hold that the prosecution has failed to prove the charge in the section 302 IPC beyond reasonable doubt as the medical evidence raises a reasonable presumption of insanity, thereby negating the necessary intent for murder. Affirm that the High Court's finding of legal insanity was in accordance with established jurisprudence and therefore does not warrant interference by this honorable court, dismissing the present appeal as devoid of merit and upholding the respondent's acquittal, pass any other or discretion that is let this honorable court may deem just and necessary, fit in the interest of justice, and for this act of justice and grace, the respondent shall, as in duty bound, ever pray.
Just one point.
Sir.
When you are taking defense of Section 84 of IPC, but you didn't say a single word on Section 105 of Indian Evidence Act. Burden shifts on you.
Yes, sir. Burden shifts on the accused side as it falls in general exception.
105 पर आप बताएं इंडियन एविडेंस एक्ट
सर
स्टैंसेस कैसे आपके फेवर में
सर Sir, it's just by one word, the burden of proving it just is by showing the preponderance of probabilities. And I'm just showing the preponderance of probabilities by just my 3 to 4 points which I stated earlier too, that there was not a guilty mind and I was insane. And the doctor has clearly testified this and it is on the record that my treatment was going on. And it can establish that I was insane, sir.
Do you remember the facts of McNaughton case? David McNaughton, उसका नाम तो उसी के साथ ये केस बना होगा, आपको पता है?
Sir, I have not read the full judgment, but I have stated it.
इसमें एक बात आती है कि छठे पैराग्राफ में सेकेंड लाइन, during interrogation, David claimed that he was unconscious when the attack took place. He stated that upon regaining consciousness, he found Emma lying on the floor with axe in his hand, and later he tried to hide this axe. Para number 6, second line and third line. Circumstances are against you, Mr. Counsel. What you say?
Sir, he is stated.
He was found axe in his hand.
Yes, sir.
His wife was.
But he has not stated that he was hiding the axe or he was attempting to hide the axe.
The axe was
In his hand. Sir, he has clearly done.
And later on, he was seen by his neighbor Mark that he was hiding it in the garden.
Sir.
So, how can you justify this circumstance under 105 and also under section 84 of IPC?
Sir, under 84 of IPC was just by the line at the time of doing the act and with in addition by reading it with section 105 of Indian Evidence Act just with preponderance of possibilities or probabilities.
Okay.
And we have also decided the names of the best speakers, best researcher, best speaker. We are not in a position to declare one, so we are declaring two. One is Nyasa Kaushik from Kapila, and simultaneously Avinash Kaushik is also there as a speaker. We award best researchers to Abilan's site, and the winner is Abilan.
Your Lordship, I am Shivansh. Representing the appellate in the state of Vedera. Alongside my co-counsel Nihal Kumar, we stand before the Honorable Supreme Court of India to contest the wrongful acquittal of the respondent David by the Honorable High Court of Vedera under Section 82 of the Indian Penal Code.
Your Lordship, considering the argument presented by my counsel, it is clear that point number 1, Imam's dying declaration is legally admissible and credible. Second point, medical and forensic evidence undenied establishes neglect and insanity defense. In this case, point number 1, David was able to
fundamental to clear when the injury is sufficient to cause death, the intention can be inferred from the nature of wounds inflicted.
Give me the example of the cooperating witness, which is this. What all are the cooperating witnesses?
The axe was found, he was found that
because the mark was just neighbor. अगर मैं एक हाइड विटनेस के तौर पे भी बोलूं, अगर मार्क जाके देख रहा है, हाइडिंग करना है कि मतलब कि वहां आके फेंक देना, हाइडिंग करना मतलब प्रॉपर तरीके से उसको हाइड करना। मार्क ने अपने स्टेटमेंट में एक तरीके से ये भी नहीं कहा है कि वो सिर्फ गार्डन में तो हाइड करने जा रहा था। गार्डन तो खुला हुआ है, तो कहीं पे भी हाइड, अपने घर के अंदर भी हाइड कर सकता था, गार्डन में ही क्यों? थैंक यू मैम।
The Republic of Organization Pacific Federal Country, both division Imam was a resident of Rebuttals, which is a town in the state of Delaware. The pretext of the case is that division Imam was married, and on 5th of December, at around 10 a.m. in the morning, there was some clashes which has taken in the
my colleagues, speaker already discussed the issue 1 and 2. Now I am seeking permission to further issue 3 and 4 and 5. Much obliged. There is issue mentioned 3, whether the evidence presented by the defense witness sufficiently establishes that the accused is an unconsciousness state due to his medical condition at the time of the attack. Now, the burden of proof under the section 84 IPC is relying on the defense side, that is section 105 of the CRPC that say the burden of proof that depends.
Good morning, my lordship. I am concealed on the behalf of respondent. May I seek the permissions to process further? Yes, sir.
What the direct declaration, how suspicious था? Like, what are your points of?
सर इसके लिए हमको स्पीकर को कॉन्सेंट्रेशन चाहिए।
So the first doubt is कि जब वो डायरेक्शन दे रही थी, उस टाइम पे वहाँ पे कोई मैजिस्ट्रेट प्रेजेंट नहीं था।
तो ऐसा जरूरी नहीं है कि मैजिस्ट्रेट के सामने डायरेक्ट डिक्लेरेशन को वो कंसेशन
का पिक करेंगे कि मैजिस्ट्रेट साहब आएंगे तब हम करेंगे। हम तो वहाँ पे मैनिपुलेशन के चांसेस
ऐसा कोई केस ना है, ऐसा कोई एक्ट में लिखा हुआ है कि डायरेक्ट डिक्लेरेशन अगर मैजिस्ट्रेट के सामने देगा तभी वैलिड होगा।
सेक्शन 31 ऑफ इंडियन एक्ट
ऐसा लिखा हुआ है उसमें कि मैजिस्ट्रेट के सामने देगा तभी उसका वैलिड होगा। डायरेक्ट डिक्लेरेशन भी लिखा हुआ है। और नेक्स्ट जब रूल भी था उसमें कहा गया है कि आपको जो है अगर आप किस समय आपने मर्डर किया उस समय का आप कंसस थे तो आपको डिफेंस नहीं मिलेगा तो कंसॉर्ट का।
सर जिस टाइम पे उसने मर्डर किया उस टाइम वो अनकॉन्शियस हो, फिर उसको जब वो रियल जब उसने कंसेस किया फिर उसे लगा वो डर गया वो इसलिए उसे छुपा रहा।
Made it the council number 1 on behalf of prosecution side of Valera Estate. If Lordship permit, have you like to proceed with jurisdiction of the case? Highly apologize.
Authorize?
Offline. Sorry. Offline. Sorry. The council humbly submitted to the jurisdiction of the Honorable Supreme Court of India under article of 134, the Constitution of India. If the Lordship will have to like to proceed with the case of the file.
Proceed direct issue number 1.
Issue number 1. My first issue is whether the dying declaration made by the deceased human is admissible and reliable evidence of determining the guilt of the accused David. तो yes मैम, डाइंग डिक्लेरेशन एविडेंस है क्योंकि इंडियन एविडेंस एक्ट 1872 और सेक्शन 32 सब क्लॉज 1 के तहत डाइंग डिक्लेरेशन को एविडेंस माना गया है। यहाँ पे एम्मा जो है वो मृत्यु से पहले बोलती है कि उसके पति डेविड ने ही उसका मृत्यु मतलब मारा है, उसको हमला किया है। लक्ष्मण वर्सेस स्टेट ऑफ महाराष्ट्र 2002 AIS 2073 में सुप्रीम कोर्ट ने माना है कि डाइंग डिक्लेरेशन एक क्लियर एविडेंस है। और जब एम्मा बोल रही थी उसका मेडिकल जो चेकअप किए थे डॉक्टर एंड्रयू थे, उन्होंने माना है कि उसका मानसिक स्थिति बिल्कुल ही सही थी जब उन्होंने ये दिया था।
Good afternoon, ma'am. Big Kriti, Council number 2, presented here to prostitution site state of Valero.
Mr. Police, learning professor, good afternoon, ma'am. ये तो सुनी ना? लेकिन next time इंट्रा कॉलेज, अभी इंट्रा कॉलेज हो रहा है, फिर अभी इंटर कॉलेज हो रहा है, तो अभी से सीख के चल।
My lordship, if your permission, then may I proceed the case? My lordship, my third issue is whether the evidence presented by the defense witness sufficiently established that accused was in the unconscious state due to his medical condition of the time of the attack. No, the accused was not in the unconscious state due to his medical condition at the time of the attack, because if he was in unconscious state due to his medical condition, then why he hid the acts? Or by noble mood disorder, एक ऐसी बीमारी है जिसमें मूड में उतार चढ़ाव होता है, ये मूड स्प्रिंगिंग होता रहता है, इसमें समय समय पे दौरे आते हैं। इस बीमारी में इंसान हर वक्त अनकॉन्शियस स्टेट में नहीं रहता है। और कभी भी डेविड के चिकित्सक जो डिफेंस विटनेस 1 डॉक्टर मैथ्यू थे, इन्होंने ये नहीं कहा कि हमला करते वक्त डेविड अनकॉन्शियस स्टेट में था। अगर डेविड अनकॉन्शियस स्टेट में होता तो वो घाव इतना गहरा देता ही नहीं जिससे कि इमा की मौत हो जाती। इसके द्वारा दिया गया
कोई लिंक ही नहीं है कि कोई बिना नोट से मारा है, इससे डिफाइंड होता है कि वो जो है बाइपोलर डिसऑर्डर से पीड़ित रही।
एंड्रयू ने जो पोस्टमार्टम रिपोर्ट दिया था उसमें बताया था कि उसको बहुत ही तेज घाव लगी थी।
The Council, on behalf of the accused, humbly seek permission to proceed with the case. Obliged. With due permission of the bench, the Council please to address the bench collectively at my law, please. Obliged.
या तो गेट के अंदर आ जाओ या तो गेट बंद करो।
The Council is here on behalf of the accused in the case of the estate of Belera versus David. With the due permission of the bench, the Council would like to brief the fact of the case. Please.
Let's go for the issue. पहले institution बस बता दूँ फिर issues पे।
The appellant has approached this Honorable Supreme Court under Article 134 of the Constitution of India.
India.
Ma'am, can I move on the issue, please? Milord, the first issue of the case is whether the dying declaration made by deceased animals is admissible and reliable as evidence in determining the guilt of the accused David. My Lord, Council humbly submitted that no doubt the dying declaration is a substantive piece of evidence, but it should carry certain circumstances when it is considered as a weak piece of evidence. And my case falls under these circumstances. The circumstances when dying declaration is considered as a weak piece of evidence. The first is lack of other evidence in corroboration. Second, mental state of the declarant. Third, no opportunity for observation. fourth, delayed recording of time declaration, and another is recorded by influence or pressure. Milord, at the time of
council, आपने ये कहाँ से किया?
Milord, I have mentioned it under
like you have written like big piece of it. This is a very strong like point. तो आपने ये कहाँ से mention किया?
I have mentioned it from criminal manual.
Which article? Which section?
Under section 32 of the Indian Evidence Act.
So I'm asking this कि आपने एक time green list आपने pointer दिया 5, बहुत strong points दिए 5.
Yes, ma'am.
तो ये कहाँ से आप refer करते हो?
Ma'am, this was given in the commentary book.
किसी judgment में Supreme Court ने बोला है?
No sir, हाँ sir, judgment में भी बोला है, but book में भी mention किया है comments में.
Just show me. And you know that the comment is not a very substantive piece to...
Yes ma'am, I also mentioned the case laws.
So that's why I'm asking now from where you refer this being piece of...
Yes ma'am, I have also clarified by case law. There I mentioned various case laws regarding this issue.
Okay, just give me the comment. I have to see.
Under subsection 1, it was mentioned and also Supreme Court said in Bharat Singh versus State of Madhya Pradesh that I have mentioned in my memorial paragraph, page number 14.
अच्छा आपने बोला कि mental state fit नहीं था उनका.
Yes.
ये तो ये हो गया कि mental state का fit था जो वो दे रही थी.
Ma'am, because Honorable Supreme Court in Admissibility versus Government of the City of Delhi. In this case, Honorable Supreme Court saying dying declaration is relevant only if supported by medical report. There are the point to be noted that the consciousness, mental fitness of the deceased and another report made by doctor for mental fitness of deceased throughout the process of declaration made. इसमें कहा गया है कि इसमें ये कहा गया है कि 2 रिपोर्ट फाइल किया जाएगा. फर्स्ट रिपोर्ट तब फाइल होगा कि जब वो स्टेटमेंट दी रही है तो दे रही है उस समय फाइल होगा कि हाँ ये मेंटल फिटनेस में है. एंड सेकेंड तब फाइल होगा जब वो अपने स्टेटमेंट रिकॉर्ड करवा चुकी है, तब वो क्लैरिफाई किया कि हाँ थ्रू आउट द प्रोसेस ये जो भी बोली है मेंटली फिटनेस में बोली है. इस केस में यही कहा गया था, लेकिन इस केस में सिर्फ एक ही रिपोर्ट फाइल किया गया कि वो मेंटली फिट है थ्रू आउट द प्रोसेस. बट बिफोर मेकिंग दिस स्टेटमेंट what is they are not submitting any report. So the first report is
Okay.
the first report is not filed by the prosecution. Milord, the statement made under section 32 of Indian Evidence Act 1972 must be made by a person who is dead immediate after the admitting a statement. Under this section, the statement of the deceased persons has been given importance under these sections as there can be laid down the statement made by the dying person himself about his death. Milord, kindly draw your attention on the date of dying declaration, that is on 6th December 2010. That death was on 8th December 2010. Then how it is considered as a dying declaration? Because dying declaration means the statement before death immediately.
ऐसे थोड़े डेथ हो गया उसका तो थोड़े बताइए कि उसका डेथ कब हो रहा है उसके बाद में आप तो डेथ तो नहीं होता है हां डेथ तो
yes
कॉज की वजह से हुआ है.
Yes ma'am, because Honorable Supreme Court in Farwar Singh versus State of UP held that if the statement made by the deceased and date of death is taken sometime, then it is not a dying declaration. It is considered as a only corroborative piece of evidence under section 157 of Indian Evidence Act. Here the difference between death and deceased and the deceased and the date of making dying declaration is more than approximately 48 hours. So it is not considered as a dying declaration. Milord, kindly
You are making very strong statements, Counsel.
Yes, ma'am.
She died after making that statement. You are saying that is not a dying declaration.
Yes, ma'am.
You are like stick on this point. That's not a dying declaration.
यस मैम, क्योंकि सुप्रीम कोर्ट ने कहा है कि अगर कोई डेथ कर रहा है, कोई स्टेटमेंट मेक किया है और उसकी डेथ इमीडिएट नहीं हो रहा है, समटाइम्स ले रही है, तो डाइंग डिक्लेरेशन नहीं होकर कोलैबोरेटिव पीस ऑफ एविडेंस बन जाएगा अंडर सेक्शन 57 ऑफ इंडियन एविडेंस एक्ट। सो हम इसको कैसे मान लें, क्योंकि इसमें भी डिफरेंस है अप्रोक्स 48 आवर्स, और 48 आवर्स में हो सकता है कि मेडिकल नेग्लिजेंस इसकी डेथ हो चुकी हो या कोई इन्फेक्शन हुआ हो। दिस वाज नॉट क्लैरिफाइड। May not kindly draw your attention on dying declaration. You found that the time when dying declaration is recorded, it is not mentioned anywhere. And without proper date and time, evidence is not properly held reliable. Honorable Supreme Court in Ram Bihari Yadav versus State of Bihar and another held that the dying declaration should contain proper date and time of making. Otherwise, it will not be accepted in court of law. Then how the lower court accept this dying declaration without proper mentioning date and time? Not only accept it, but also convict the accused on the relying upon this. Honorable Supreme Court in Admissibility versus NCT of Delhi held that dying declaration is relevant only if supported by two types of evidence. Medical report. First report is filed when the statement is going to be made, and second after the statement is recorded. और वो स्टेटमेंट ये क्लैरिफाई करेगा कि थ्रू आउट प्रोसेस ये जो है मेंटली फिट रही है, बट डॉक्टर यहाँ पे PW2 जो है वो सिर्फ और सिर्फ एक ही रिपोर्ट सबमिट किए हैं कि ये थ्रू आउट प्रोसेस मेंटली फिट है। उससे पहले उसका क्या स्टेट था, दिस वाज नॉट मेंशन्ड एनीवेयर। मे नॉट काइंडली ड्रॉ योर अटेंशन ऑन सेकंड इशू। The second issue of the case is whether the medical evidence regarding the deceased injury and the cause of death establishes a clear link between the attack by accused and the fatal injury. The counsel humbly pleaded to the bench that the medical evidence regarding deceased injury not completed. PW2 stated that the injury caused through an axe, but how it is possible for doctor to treat the deceased? डॉक्टर के लिए पॉसिबल नहीं है, जो ट्रीट कर रहे हैं उनको कैसे पता चलेगा कि एक्स से इसकी डेथ कॉज हुई है या किस विपद से इसकी डेथ कॉज की गई है?
कैसे नहीं पता चलेगा? अपने फैक्ट से बहुत क्लियर नहीं है। जिस भी हथियार से आपको चोट लगता है, आपके पास वो हथियार भी है, फॉरेंसिक एविडेंस भी है, तो कैसे नहीं आप?
मैम, फॉरेंसिक एविडेंस हैज आल्सो फॉर फॉरेंसिक एविडेंस में सिर्फ और सिर्फ बोला गया है कि उसके एक्स पे उसका फिंगरप्रिंट मिला है।
दैट्स द कोलैबोरेटिव थिंग ना, आई विटनेस था जिसने देखा उसको छुपाते हुए एक्स।
मैम, हम
तो उसमें उसकी फिंगरप्रिंट आई, आपको पूरा कोलैबोरेट करना था ना उसमें।
मैम, उसको आई विटनेस कैसे मान सकते हैं PW3 को, क्योंकि उसने अटैक करते हुए तो देखा नहीं, वो सिर्फ देखिए कि हाँ वो जो डिसीज है वो अनकॉन्शियस स्टेट में कवर।
लास्ट स्टेट की पढ़े?
यस सर।
लास्ट स्टेट की क्या
सर? उसमें दिया गया है कि जो डेथ से पहले अगर दो व्यक्ति को एक साथ देखते हैं और अगर उसमें से एक की डेथ हो जाती है तो ये बर्डन ऑफ प्रूफ चल जाता है दूसरे पे कि आप प्रूफ करो कि हाँ आपने ये मर्डर नहीं किया है। यस सर, आई हैव आल्सो कम ऑन दैट पॉइंट। सर इसमें ये दिया गया है कि ये जो है चूंकि इसमें कहा गया है डॉक्टर के द्वारा कि जो ट्रीट कर रहा है वही कह रहे हैं कि हाँ एक्स के कारण इसकी डेथ किया, उसी से चोट लगा है, बट दिस वाज अ मैटर ऑफ पोस्टमार्टम रिपोर्ट, क्योंकि पोस्टमार्टम रिपोर्ट में ये पता चलेगा कि हाँ डेप्थ कितनी डेप्थ तक विपन गई है, डेप्थ का विथ क्या था विपन का, वो सारा चीज पोस्टमार्टम रिपोर्ट से पता चलेगा, जो कि एब्सेंस है इन दिस केस। प्रोसिक्यूशन के द्वारा पोस्टमार्टम रिपोर्ट कहीं सबमिट ही नहीं किया गया है। मिलॉर्ड ऑनरेबल सुप्रीम कोर्ट,
जो जैसे आप बोल रहे हैं कि लास्ट स्टेट में बताइए कि आप क्या करोगे, आपको प्रूफ करना बॉडी का प्रूफ आप ले जाए, और दूसरा चीज ये भी है कि आप सेक्शन 84 का जो डिटेल्स ले रहे हैं एक्ट ऑफ साउंड राइट का, वो डिटेल्स आप इसलिए ले सकते हैं क्योंकि आप तभी आपको समझ में आ रहा था कि कोई तीसरा आदमी आ गया था, आप छिपा रहे थे।
नो सर, आई एम सॉरी टू से दैट आई एम नॉट एग्री विद यू, बिकॉज़ सर उसमें ये था कि वो कह रहे हैं कि हाँ वो हथियार छुपा रही थी तो उसका इंटेंशन था कि आप उसका डेथ कर दो, डेथ कॉज करें, बट सर चूंकि उनको था बाइपोलर मूड डिसऑर्डर, और इस बीमारी का एक लक्षण ये भी है कि रिकरेंट अटैक आता है इसमें, और ये हो सकता है क्योंकि ये एक ह्यूमन
सॉरी टू इंटरप्ट यू, बट वो भी तो छिपा रहा है ना। अगर उसको एक्ट का इंटेंशन या अपना इंटेंशन या एक्ट की ग्रेविटी नहीं पता, फिर नहीं छिपाता, वो तो रखे रहता, वो शॉक में रहता, क्योंकि वो तो आगे के स्टेटमेंट से मैं इन्फ्लुएंस ले रही हूँ कि आपने बोला कि आते रहता है लाइक पीरियड उसको वो चीज, ये तो शॉक में हो जाता है ना, बट वो तो छुपा रहा था, मतलब उसे नहीं दिखाना था लोगों को कि उसने क्या किया है।
मैम बिकॉज इट इज अ जनरल ह्यूमन नेचर, अगर कोई, चूंकि हमारे आईपीसी में अंडर 7 इयर्स को भी प्रोटेक्ट किया गया है, लेकिन अगर वो कोई क्राइम कर देता है और अगर उसके सामने जाएंगे तो ये ह्यूमन नेचर है तो वहां से भागना चाहेगा।
उसको कैसे पता देखिए सेक्शन 84 में वर्ड यूज किया कॉन्ट्ररी टू लॉ, आपको पता नहीं कि आप जो कर रहे हैं वो कॉन्ट्ररी टू लॉ है।
Testimony is also confirming their legal trying to hide the facts. Plus, previous fingerprint has also been gathered by forensic department. Dr. Andrew also confirmed Emma's dying declaration and also confirmed that she was in a fit state. But all this corroborated evidence which has been produced by prosecution side, it is only proving accuracy, but not beyond doubt whatever the evidences which they have provided. Here also, eyewitness plays a very crucial role in any of the criminal cases. So here,
now the council seeks permission to further initiate proceeding with the issue number 5. Whether the acquittal by the High Court on the basis of legal insanity is legally sound and in accordance with the established standard of the mental fitness required for the defense under section 84 IPC. अगर हम लोग सुप्रीम कोर्ट के केस को देखें, हरि सिंह गौंड, पेज नंबर 19, हरि सिंह गौंड वर्सेस स्टेट ऑफ मध्य प्रदेश, outline that this need not to be permanent insanity, but must exist at the time of the act, provable by medical evidence and conduct. And the High Court relied on the Dr. Matthew's testimony that bipolar disorder caused violent episodes with loss of control corroborated by the David's history as per the defense witness too, and his post-incident behavior, that is unconsciousness claim. This aligns with the medical definition of bipolar disorder. The manic phrase can impair judgment and awareness, that is said by the National Institute of Mental Health, NIMH. The prosecution's evidence focused on the physical act does not contradict with this medical incapacity, and there is High Court's finding of legal and medical insanity reflects judicious balance of experts' testimony and the legal standard. It correctly distinguishes with the general aggression and argued by the prosecution and specified during the attack. Now the respondent successfully submitted the state of Valera's appeal lacks merit. The dying declaration reliability is questionable. The medical evidence does not establish mens rea, and the defense convincingly proves David's insanity under Article 84 IPC at the reasonable doubt. The prosecution's failure to disapprove it, the defense beyond reasonable doubt, coupled with the High Court's sound application of law, justify David's acquittal. The Honorable Court is urged to dismiss the appeal and uphold justice affording the High Court's judgment of 5th September 2016. Now, now the bench is satisfied. We initiate last minute prayer. Therefore, in the light of the issue raised, argument advanced and the authorities cited, it is prayed that the Honorable Supreme Court of Korea may be pleased to hold that the prosecution has failed to prove murder beyond reasonable doubt The dying declaration reliability is questionable. The medical evidence does not establish mens rea. The Honorable Supreme Court of Korea can uphold justice by affirming the High Court's judgment on 5th September 2016 and pass any other direction or relief that may be deemed fit in the best interest of justice, fairness, equity, and good consciences. And for this, the applicant, as in duty bound, shall humbly pray the counsel on behalf of respondent. Thank you.
If your lordship permits, I would like to give a reply in just 1 minute. I have objection. Just and this is not a rebuttal, sir. Just one line submission and an objection.
क्या रेज करना
Objection, please.
Thank you, Lordships. First of all, the learned counsels for the respondent has admitted that due to depression, they were hiding tax. As such, they have committed the offense. And second one, no one is out the court, but they have disregarded the procedure of court. As they have taken the time also, and it was a procedure that the speakers, two speakers were allowed, but one by one. It was not given in the moot proposal that the speaker can come after the submission of second speaker also. So this is just my objection. And the main point is that they have admitted that they have committed the offense and they should be held liable for the thing. Thanks, Your Lord, for applying.
Charge.
इसमें आप सब एक भी जगह एक्सपर्ट ओपिनियन कहाँ दिया है
45, section 45.
डिफरेंस बताइए शेड्यूल और लीगल स्टैंडर्ड
Legal insanity means inability to understand the nature of an act. Medical insanity depends on medical grounds. It is condition when individual cognitive faculty is suspended.
The counsel's explanation to call the bench collectively as negotiable.
Supreme Court may be please hold the acquittal granted by the High Court based on the Section 84 of the IPC as David was legally insane, recognized a medical evidence providing the David's unconscious state during the act, rejects Emma's dying declaration due to doubts over his reliability, acknowledge that the lack of the mens rea making the conviction under Section 302 of the IPC unsustainable, consider the medical rehabilitation for the David instead of punishment, grants any further relief if just and fair, and pass any order as the Honorable Court may be fit and proper in the interest of justice, equity, and good conscience.
भूमि परिवार
Ansuti.
Then we legal insanity. Council treatment पे rehabilitation के बारे में दिया उसने.
फील मीडिएट एविडेंस एक्ट के इस सेक्शन में आप प्लीज गेट करेंगे सारे एविडेंस इलेक्शन से प्रूफ कर रहे हैं
105 of written evidence.
क्रिटिकल इंसैनिटी है लीगल इंसैनिटी
सर मेडिकल इंसैनिटी होता है कि व्यक्ति मेंटल इलनेस से सफर कर रहा हो और लीगल इंसैनिटी में ये होता है कि वो एक्ट करते वक्त अपने एक्ट के नेचर को नहीं समझ पा रहा हो और राइट और रॉन्ग में डिफरेंशिएट नहीं कर पा रहा हो उसको लीगल इंसैनिटी बोलेंगे।
और आप इसको पास से अब आप इसको पास क्या हुआ
उसमें डेनियल एम नाम के व्यक्ति थे जो कि ब्रिटिश प्राइम मिनिस्टर के जगह पर एडवर्ड डमन नाम के व्यक्ति उनको मार दिए थे क्योंकि वो पागल पड़ने से गुजर रहे थे। इस बेसिस पे जो कोर्ट है उनको अपील कर दिया था जिसपे जो पब्लिक है वो उन्हें आक्रोश निकला है। उसी वक्त जो लीगल इंसैनिटी केस का जो रूल बना उसी टाइम बना था। अंशु से